Okay, we're talking about an advancement as being an advancement in knowledge.
Yeah.
And I think you said it perfectly here, that it really is to say it's an advancement in the general understanding. Mm-hmm. Now, having said that, you did pre-qualify this decision by defining it as routine engineering as being data, techniques, procedures, and data that are not generally accessible. So it's understood that when you're saying, did the process result in a technological advance, that is to say an advancement in general understanding, of course, the meaning would be knowledge that was not generally available. I think that's very clear. And again, that's a decision that I think is a definition that I think is the most clear of all. But I think you've done another service for taxpayers and for CRA in general, and for all of the courts. By the way, this decision's been cited in every case that's ever been heard by the Tax Court of Canada, and also has been cited several times by the Federal Court of Appeal. This is good law. You've essentially created and shaped the law that everyone depends on. And I think a lot of credit, obviously, goes to you. But what you've done here is, in this part of your decision, is you've taken it further. You've already stated that routine engineering involves knowledge that's not generally available. Now, you've gone further. You've, in effect, defined what generally available means. You say, a technological advance in Canada does not cease to be one merely because there's a theoretical possibility that a researcher in, say, China may have had the same advance, but his work is not generally known.
That's true.
So I think that in order to, just to step back for a minute, if you don't mind, in order to define an advancement, you have to know what the uncertainty is. If an advancement means resolving a technological uncertainty, in an income tax law, it's generally held that an advancement in technology is inextricably linked to the resolution of a technological uncertainty. Would that be true?
Yeah.
Would it also be true then that in order to determine to what extent there's been, or if there has been an advancement, what is routine engineering? You'd have to be able to demonstrate, like anyone can say, we advanced technology by exceeding routine engineering. But if you don't define what routine engineering is, it's not very strong, is it?
No.
So here I think you've done that for us. You've made this very usable. You've made the SR&ED program accessible, and you've made it very user-friendly. Because what you've done here is you've defined what generally accessible is. So why did you decide to express it the way you have? I mean, obviously you had a choice. And to how much latitude do you afford taxpayers who are making a claim for advancing knowledge? And you could have said it very differently. You could have said, well, if the knowledge exists, then it's generally accessible. But you didn't say that.
No, I didn't, because I wouldn't have thought it.
Why?
Why? Because I don't believe that if it happens to be known to a few people on a Caribbean island, that in itself is not generally known.
Interesting way of putting it. There's a fairness there. There's a fairness there. And I think that if in fact, in the wisdom of the legislature, it was their intent to promote scientific research in Canada, then I believe that one should try to look at things in a fair way. And I don't know that this is necessarily the way that it's being considered. Like, we understand that the burden of proof is on the taxpayer to be able to demonstrate they gain knowledge. That's clear. But what we're not seeing is evidence that it's being produced by the minister in many situations to say, well, here's an example of where this knowledge comes from. It's routine engineering because it's my opinion. Would you think that the CRA would do well to increase the training on reviewers with respect to the case law?
I suppose they would. I don't know. In the many cases that I've heard involving scientific research, the witnesses that they call as experts on behalf of the Crown are well qualified.
Well qualified, and they're well spoken.
Oh yeah.
In fact, I would suggest that would be one of the problems that many of the cases have when CRA calls an expert witness or, say, a material witness. These are individuals who are accustomed to stating reasons why claims are denied. When the appellant calls its witness, they may have never done so before.